Good day, Crime Talk aficionados. My name is Scott Reisch, and this is Crime Talk, the most fact-driven, unbiased, true crime channel. First on the docket, witnesses have been endorsed for an upcoming hearing in the Lori Vallow Chad Daybell matter. Are we really going to have a hearing? Second, judge rules that there are aggravating factors, and they will be considered in Derek Chauvin's sentencing. Third, an example of why eyewitness identification should be viewed with a skeptical eye. Fourth, a good example of good initiative, poor judgment? Maybe. And finally, our dumb criminal contestant of the day. Let's talk about it. Good day, Crime Talk aficionados. This is Crime Talk, and my name is Scott Reisch. Thanks for tuning in. Now, if you haven't done so already, please hit that subscribe button as well as that little bell so that you receive notifications of when we go live or put up new content. And I hope you enjoyed the show last night. It was live, and then we did our Patreon. Everyone seemed to have a great time. Please join us next Tuesday as well. Now, first on the docket today, witnesses have been endorsed for the June 9th hearing. John Pryor, attorney for Chad Daybell, signed this disclosure of expert witnesses and lay witnesses. Now, as you may recall, there were some issues regarding witnesses previously being endorsed as it related to the change of venue. And the defense witnesses wouldn't basically turn over any reports. And for lack of a better term, it turned out to be just one big cluster. Well, we now have that hearing coming up on June 9th. The expert witnesses that have been endorsed, and it says expert witnesses, representatives from Ironwood Insights, previously disclosed by counsel for Mrs. Lori Vallow Daybell, which is interesting because I went back and looked, although quickly, I never saw this endorsement, but I may be mistaken. Anyway, Ironwood Insights, what are they? Looked them up really quickly. They are actually located here in Aurora, Colorado, and they are basically a data collection site. So if you want to conduct a survey, product evaluation, have these people, they call out, they do a bunch of surveys, they may do some face-to-face interviews, but the reality of it is they're going to take a survey, ask a question, come up with the results, and give you the statistics. Now, clearly what the defense is trying to say is that the trial should be changed and the venue should be moved. I'm frankly not sure why anybody is fighting this, given the small jury pool, the demographics, the fact that this story is big news out there in East Idaho. I'm just not sure why the judge doesn't do it on his own. I get that they need to have a hearing on it, and I'm not sure why the prosecutor wants to fight it much anyway. I mean, frankly, I don't think you're going to get a jury pool there. Now, lay witnesses that have been endorsed are Andrea Fricke, previously disclosed by counsel. As my recollection is, she was one of these surveyors that didn't want to disclose everything. Remember, she's a lay witness. Heather Daybell, Chad Daybell's sister. Nate Eaton, he's a reporter for the East Idaho News. Not really sure what he can testify about other than maybe the sheer number of stories that he's done on this particular case, the fact that the East Idaho News has their own basically little section on their website, and that obviously it's a story of great interest in the area. And then we have a gentleman by the name of Joe Adriani, Joe, and then Adriany. Not exactly sure what they're going to testify to whatsoever. Now, normally when one has an expert testify, you have to produce an expert report. Now, I'm not sure if this report has been turned over to the prosecution yet. It has not been made yet available to the public. And what I mean by that is they're not going to just put it up online, but it hasn't been at least attached to any court filings. If it were attached to any court filings, at least we would be able to see it. So now I guess we all just have to tune in on June 9th. We'll bring it to you here on Crime Talk, so please join us for that. Next on the docket, Derek Chauvin has had a bad couple of weeks. First, he gets found guilty of all 3 charges brought by the state against him. Then he gets indicted not once but twice in federal court for civil rights violations. And now the judge who oversaw his criminal case in state court, Judge Cahill, has ruled that there were in fact aggravating factors, and the court is going to consider those at sentencing. So Judge Peter Cahill found that Chauvin abused his authority as a police officer when he restrained Floyd last year, and that he treated Floyd with particular cruelty. The judge also cited the presence of children when he committed the crime and the fact that Chauvin was part of a group with at least 3 other people. Those are all aggravating factors that the court can consider. Cahill said Chauvin and 2 other officers held Floyd handcuffed in a prone position on the street for an inordinate amount of time, and that Chauvin knew the restraint was dangerous. The court further found the prolonged use of this technique was particularly egregious in that George Floyd made it clear he was unable to breathe and expressed the view that he was dying as a result of the officer's restraint. Now, even with these aggravating factors, many believe that Chauvin, who's now 45 years old, is unlikely to receive a sentence of more than 30 years. 30 years is a long time, no doubt. Now, even though he was found guilty of 3 counts, under Minnesota statutes, he'll only be sentenced on the most serious charge. That's called murder, second-degree murder. And under the Minnesota sentencing guidelines, he would have faced a presumptive sentence of 12 and a half years on that count. And Cahill could have sentenced him to as little as 10 years and 8 months or as much as 15 years to stay within the guideline range. But the prosecutors are asking for what they refer to as an upward departure. And the prosecutors are arguing that Floyd was particularly vulnerable with his hands handcuffed behind his back and that he was face down on the ground. The prosecutors noted in their motion that Chauvin held his position even after Floyd became unresponsive and officers knew he had no pulse. So what the court's ruling does is it gives the judge, Judge Cahill, permission under the law to sentence Chauvin above the guideline range. Though he doesn't have to, both sides will argue whether an upward departure is appropriate and how long the sentence will be. Ultimately, that decision is with Judge Cahill. The court states that Chauvin treated Floyd with particular cruelty. The judge wrote, "The slow death of George Floyd, occurring over approximately 6 minutes of his positional asphyxia, was particularly cruel in that Mr. Floyd was begging for his life and obviously terrified by the knowledge that he was likely to die, but during which the defendant objectively remained indifferent to Mr. Floyd's pleas." Not a good sign for the defense. If you can read anything into that, it looks like he's going to get whacked really hard at sentencing. Now, one must remember that no matter what the sentence is ultimately handed down for Derek Chauvin, in Minnesota, it's presumed that a defendant with good behavior will serve 2/3 of the penalty in prison and the rest on supervised release, commonly known as parole. So think about it. If he gets a 30-year sentence, 2/3 of that, you can do the math. He's going to spend the next couple of decades in prison. Needless to say, Derek Chauvin has had a bad couple of weeks, and I think it's going to get even rougher. Let's take a quick recess before we continue on with the docket. Please go to CrimeTalkSearch.com, sign up for a background subscription service. You'll be happy you did. If there's anyone out there you were ever curious about what was in their background, now is the time to do it. If you're going to get involved with somebody, now is the time to do it. When you go to CrimeTalkSearch.com, you put in the name, literally millions of public records are searched, and a report is generated. And it's going to give you a report. If they have multiple social media accounts, you're going to find it. If they have multiple phone numbers, multiple email addresses, it's going to be found. And more importantly, you're going to get information regarding criminal history. Hopefully the person you're searching has none whatsoever. But if it's there, it's going to be found. You're going to get everything you'd want to know, whether you're going into business or whether you're going into a personal relationship. You're going to be able to find out the information you want to know. So go to crimetalksearch.com, sign up today. You'll be happy you did. Next on the docket, an example of why eyewitness identification should be viewed with a very skeptical eye. Please meet Kevin Strickland. Now, according to the prosecutors that prosecuted him some 42 years ago, they believe that he has been wrongfully accused and wrongfully convicted, and they want him to be completely exonerated. Well, Mr. Strickland has served more than 42 years in prison for a triple murder. And now, as I said, the prosecutors say the evidence used to convict him doesn't add up, and they don't believe that he should be behind bars. Strickland was 18 in 1978 when the sole survivor witness of an attack in a Kansas City home that killed 3 others, Sherry Black, John Walker, and Larry Ingram. They're identified as a particular participant in the shooting. The witness, Cynthia Douglas, was shot in the leg, and she survived by playing dead. Immediately after the shooting, Douglas named 2 other men, Vincent Bell and Kilm Adkins, both of whom pled guilty to the charges. But that night, despite knowing Strickland personally, Douglas could not identify a third man holding a shotgun and didn't change her mind until the next day when her sister's boyfriend suggested it might have been Strickland. Now, this was according to a letter written by Baker to advocates with the Midwest Innocence Project. Just pick Strickland out of the lineup and we'll be done. It will all go away. And you can go on and you don't have to worry about these guys no more. That's what Douglas said when she was told in a recollection shared with members of the Strickland legal team. Now, Douglas, whose testimony proved pivotal in Strickland's conviction for the murders, eventually recanted after hearing the confessions of others, including Bell, who said in 1979, "I'm telling the state and the society out there right now that Kevin Strickland wasn't there at the house." In 2009, Douglas herself contacted the Innocent Project, according to news reports. She stated, "I am seeking information on how to help someone that was wrongfully accused. This incident happened back in 1978. I was the only eyewitness and things were not clear back then, but now I know more and would like to help this person if she could." Now, Douglas has since died, but for many years until her death in 2015, Douglas repeatedly expressed to her family members and others both her doubts about her identification of Strickland and her wish to see him exonerated. Strickland, who's now 61 years old, has spent more than 2/3 of his life in prison after the 2 men who pled guilty said he did not accompany them or 2 other accomplices during the April 25th, 1978 incident, according to the incident published by the Kansas City Star. Now, the Innocent Project has filed a petition asking the Missouri Supreme Court to release and exonerate Strickland. They state in the petition that once she became aware of her mistake, Ms. Douglas did everything she could to free Mr. Strickland, and she bears no responsibility for the years Mr. Strickland has lost. They further argue Mr. Strickland's conviction was the failure of a system and the injustice of his continued incarceration harms not only him, but the families of the victim who must continue to relive this horrible crime as we fight to correct the injustice. Now, a hung jury initially failed to convict Strickland, but he was convicted at a second trial by an all-white jury based almost entirely on the unreliable eyewitness identification of the surviving victim. Now, the Jackson County Prosecutor's Office, which began reviewing the case last fall after an investigation went forward from a request from the attorney from the Innocence Project, said, for a variety of reasons, including Strickland's representing himself on appeal, never a good thing. The full picture of this era of justice was not made clear until recent months. No timetable has been set for the Missouri Supreme Court to consider the petition for Strickland's release and exoneration. Hopefully the court will do the right thing. What's also interesting is that the prosecutors, one is passed and one still alive, believes that Strickland is now innocent. And the other prosecutor states that the prosecutor that has passed would be absolutely advocating for the release of Mr. Strickland. This, my Crime Talk aficionados, is why eyewitness identification should be viewed with such skepticism. It is subject to suggestibility. It is subject to people being persuaded that somebody was in fact there. And if appropriate, line up identification procedures, which now are based more on science than what they used to be 42 years ago, they simply are not reliable. Next on the docket, and I say this with a grain of salt, good initiative, poor judgment. Now, I'm not advocating in any way for anyone to go steal or burglarize someone else's home, all right? But Rockham Prowl, he's 30, and he's been charged with 2 counts of burglary, grand theft, and 1 count of vandalism in Beverly Hills. Officers had been investigating a string of burglaries in an affluent suburb, and that they noticed, based upon video, that the suspect's mouth always appeared to be open when they would view the video. They then realized that the burglar was wearing a mask, which gave him an appearance of a white man with thick brown hair. And you can see from the picture, he kind of looks like his mouth is wide open. Now, Prowl from Inglewood, California, was linked to the 2 burglaries on April 20th and July 20th of 2020, in which flat screen televisions were stolen. He was arrested on May 2nd during a traffic stop, with officers then finding a face mask and other items that connected him to the burglaries in the car. The license plates on the car were also stolen, according to the authorities, and a further search of the home revealed more stolen items connecting him to additional burglaries. Prowl has been released from police custody and will appear in court on May 25th, according to police records. Now, when I say good initiative, I'm jokingly, half-heartedly, but Mr. Prowl must watch Crime Talk. Because what do we talk about? What is always so important? That's right. They have to prove identity. They have to prove that it was in fact the defendant, not someone that looked like him, not someone using his identity, but it was in fact him. In this particular case, when the mask is found in the car where there are a bunch of stolen goods, not looking good for Mr. Prowl. Now, obviously, we'll give him the presumption of innocence. Perhaps maybe he was just borrowing a friend's car and just haphazardly happened to be pulled over and stopped and is now implicated in being falsely accused. We'll just have to wait and see how things turn out. We'll keep you posted as we get information as well. And finally, our dumb criminal contestant of the day. And why do our dumb criminal contestants of the day always have such complicated names? Audrey Fransquini. She's 28. And what is her crime? What did she possibly do? She went to a Florida high school and she dressed as a high school student. Why? What nefarious acts would she be doing in there? Well, she was handing out flyers at the school to promote her Instagram page. Now, when the security officers became somewhat suspicious of Miss Fransquini's walking about the school and not stopping, guess what they did? They gave chase. Well, when they caught her and the police spoke with her, she was almost giddy and wanted to show them video that she had taken while basically undercover infiltrating the high school. Well, she has been charged with burglary, interference with an educational institution, and resisting arrest without violence. That's right, Miss Fransquini, you are our dumb criminal contestant of the day. I don't know, maybe if you wanted to promote your Instagram page, you could just put up good content. You didn't have to go into a school. People get a little jittery when people aren't supposed to be in school. They're carrying a backpack as well as a skateboard. And then you run when they try to talk with you. People get a little nervous. They've had a couple of incidents at schools. Maybe you've heard of a few of them. For that, Miss Franquini, you are a dumb criminal contestant of the day. All right. Our contestants will come throughout the week, and they will all be competing for the grand prize of the Dumb Criminal Contestant of the Week, and the winner shall receive some cool Crime Talk swag. If you want that swag without having to become a Dumb Criminal Contestant, simply hit the link below. It'll take you right there to our page, and you can order to your heart's desire and get your Crime Talk swag. All right. Thanks for watching. Have a wonderful day. We'll see you next time on Crime Talk.